Article 54 of the Family Code of the Philippines states that children conceived or born before the judgment of annulment or absolute nullity of the marriage under Article 36 has become final and executory shall be considered legitimate. Children conceived or born of the subsequent marriage under Article 53 shall likewise be considered legitimate. Article 54 of the Family Code talks about the status of children. There are two kinds of marriages referred to in Article 54 of the Family Code that can produce legitimate children prior to their declaration as void marriages. They are those marriages under Article 36 where there is psychological incapacity, and those marriages under Article 53 where the decree annulling or declaring the marriage void, the partition, distribution of properties of the spouses, and the delivery of the presumptive legitimes of the children have not been recorded in the proper civil registry or registries of property. Under Article 36 of the Family Code, a marriage where one of the parties is psychologically incapacitated to perform his or her essential duties to the marriage is void from the very beginning. Meanwhile, under Article 53 of the Family Code, the marriage subsequently contracted by any one of the spouses in violation of the rule in Article 52 is void. Both are void marriages, but these two marriages can produce legitimate children provided that they were conceived prior to the judgment that declares them void and that has become final and executory. The marriages in Article 36 and Article 53 of the Family Code can produce legitimate children because without their defects, they would have been valid. The children produced under these articles are not to be blamed for the misfortunes or misgivings of their parents. As previously stated, since a voidable marriage is considered valid prior to the judgment of annulment, children conceived or born before the judgment of annulment has become final and executory are considered legitimate. Children born of void marriages under Article 36 and 53 of the Family Code, which are exceptionally considered legitimate. Thus, if the marriage is judicially declared an absolute nullity, the family court shall order the local civil registrar to issue an amended birth certificate indicating the new civil status of children affected, except in cases of children under Article 36 and 53 of the Family Code. Finally, anyone who alleges the illegitimacy of such child has the burden to prove it.